Hello, I'm Kimberlie Acosta. Welcome to the Native News Update. It's Thursday, December 9th. Many of the stories you hear here can be found at our website, IndianCountryNews.com. And here's the news for the day from the Associated Press and other Native news sources. A federal judge has rejected a lawsuit challenging California's voter-approved ban on affirmative action in public university admissions. U.S. District Court Judge Samuel Conti on December 8th ruled against a challenge to Proposition 209, which banned the consideration of race and ethnicity in public education, employment, and contracting. The lawsuit was filed by the several pro-affirmative action groups that argued the law violated the civil rights of blacks, Latino, and Native American students who are underrepresented at the state's most prestigious campuses. President Obama has signed landmark legislation to pay American Indian landowners and black farmers $4.6 billion to address claims of government mistreatment over many decades. At a signing ceremony at the White House, the president declared, "It's finally time to make things right." Obama promised during his campaign to work toward resolving disputes over the government's past discrimination against minorities. The measure he signed December 8th settles a pair of long-standing class action lawsuits, including the Cobell Settlement. For more information on the Cobell lawsuit, you can check out CobellSettlement.com. A new program that has the support of Wisconsin tribes is aimed at supporting Native Americans released from prison in an effort to reduce the chance they commit future crimes. The Wisconsin Indian Tribal Community Reintegration Program is set to launch in January. Officials plan to fund the program with a $287,000 federal grant, as well as projected $125,000 from state resources. Officials plan to coordinate services for motivated inmates about 6 to 8 months before they are released. The hope is to have a job and housing set up for their return to society. The program also will link convicted felons with resources and create services if there is a need, said Ada Deer, former Assistant Secretary for the Bureau of Indian Affairs in the U.S. Department of the Interior. The Oneida-based program will reach out to inmates statewide, she said. The Oneida, Menominee, Stockbridge-Muncie Community Band of Mohicans, and the Great Lakes Intertribal Council partnered with this program. Representatives from each community were on hand to sign the document on December 8th. And today we're speaking with Paul DeMain, who's in Rapid City, South Dakota, covering the John Graham trial for the murder of the Native American activist from 1975, Annie Mae Aquash. We're here with Paul DeMain, who's in Rapid City, South Dakota, and we're going to talk about the closing statements for the John Graham trial. Do you want to give us an update on that?
Closing statements did take place this morning in Rapid City, South Dakota, in the trial against John Boy Patton Graham in the murder of Annie Mae Pictou Aquash. Of course, yesterday the defense rested without calling any witnesses. They had, my understanding, a couple of hours of haggling over jury instructions, and when you go through all this stuff, you get to the point where you begin almost to understand some of the legalese that's going around there, because it has been a case of technicalities, even though the defense attorney, John Murphy, says this isn't a trial about technicalities. It has been. It's been waiting to be tried for almost 8 or 9 years now, since the indictments took place and the extradition took place and the transfer of jurisdiction from the federal government to the state government for John Graham. The trial is over with. The evidence presented against him is now being judged by the jury. This morning, the prosecution opened up with their beginning statements. They always get the last call. They each had about an hour and 10 minutes apiece. So the prosecution took 40 minutes of that for their opening statement, in which they outlined the case, underlined what aiding and abetting means and the elements of aiding and abetting that had to be proven and why, jurisdictional issues about the fact that this crime came through Pennington County, South Dakota, even though it started in Denver, Colorado, and ended up in Bennett County or Jackson County on the Pine Ridge Reservation. Jurisdiction is conveyed upon any county in which the crime took place in, even if it was over multiple jurisdictions. That making that clear to the jury had to do with a lot of the sequence of events. And so the prosecution pointed out the number of people who testified in Denver, Colorado about Annie Mae being picked up and being kidnapped in Denver, Colorado. The fact that John Graham was there, that he was placed in the car all the way to Rapid City, South Dakota, that she was interrogated at the Wickledock offices of Attorney Bruce Ellison here in Rapid City, South Dakota by Madonna Gilbert and Lorelei Dakota, relatives of Russell Means, that she was then taken to Thelma Rios' house. Thelma Rios has pled guilty to the kidnapping charge already previously. She was then taken to Bill Means' house on the Rosebud Reservation, then to Dick Marshall's on the Pine Ridge Reservation, where they refused to keep her there or to tie her up or to put her in the basement, where allegedly the gun and the bullets were provided. And basically the prosecution says to the jury, you saw the demeanor of Mr. Marshall. It's up to you to decide whether or not he was lying. It was interesting that he had a demeanor in which it was very defiant, in which he lost his memory at certain key moments on the witness stand. He couldn't remember anything. But I think they've placed John Graham, Theda Nelson Clark, and Arlo Looking Cloud there, based not only on Arlo Looking Cloud's testimony, but the testimony of Cleo Gates and Dick Marshall in part, and there to Wombly, where she was executed, and the narratives that Arlo has made over the years always contain John Graham. The element by the prosecution attorneys that the jury needs to judge us by is the fact that John Graham does not have to be shown to be the trigger person in this case. As long as he aided and abetted the kidnapping, which ended up in murder, they can find him guilty. And those kinds of jury instructions are in depth. They went through the case. Murphy came back as an alibi, basically said that it was, the prosecution almost did things that might have could have created a situation in which they could lose their bar license. That is that they put a bunch of liars up here, a bunch of people who made things up, that it was a disgrace that they brought someone in like John Graham, that they would bring in a FBI employee like Kamuk Ekafy, and he called her an FBI employee who was making a living off of taking money from the FBI to create their stories and everything. So he pretty much he went after everybody on the prosecution side, whether you're working with the prosecution willingly or reluctantly, or whether you're the hardest aimed core radical there was. Murphy went over everyone and said this was a big conspiracy, that the murder took place at a time when his client wasn't there. He said that John Graham probably took Annie Mae from Denver, Colorado to Pine Ridge Reservation right after Thanksgiving, and that the ride that everyone's talking about didn't have anything to do with his client, that his client wasn't there, and he proposed that Annie Mae was even alive up in February 1976 and might have been a victim of some kind of a hit-and-run accident that was reported by Irene Blackrow. I don't think it's believable to most of the people that were sitting in the audience. And basically, the prosecution pointed out, and just like a lot of other people said, in order to do this, I mean, he said, look, it's a shameful act that the prosecution ever brought Arlo Looking Cloud in to create this great conspiracy to convict an innocent man. And considering that he called Arlo Looking Cloud an alcoholic and a drug addict and a prolific liar and someone who knows how to manipulate the city, the prosecution pointed out that you would have to say that the whole prosecutional system took a guy that they knew would lie, could be manipulative and everything else, and would discredit himself, and built a conspiracy with another 30 witnesses around it, and that Arlo Looking Cloud is the key witness. And it just wasn't the case. He was the person that was there. Arlo's had a rough life. He's tried to diminish his role in this thing from the beginning to the end for 35 years. He was scared and fearful about the knowledge he had, and he has difficulty on the stand in a public forum. He's not a public speaker. But Arlo was omitted as an accomplice of John Graham as a key evidentiary person, and so the prosecution had to point out all the different places where witnesses corroborated what Arlo Looking Cloud was saying, and I think they did that. I think the feeling today is that there's a good chance that there will be certainly amongst all the people with the Aquash family and everything, that there's going to be a finding of guilt on the jury side for one charge or the other. Remember, he's got a premeditated murder charge and an aiding and abetting murder charge up there, and the jury can find him guilty of it by finding that he participated in either the kidnapping or the premeditated murder. On the other hand, on the defense side, there's some members of John Graham's family that was here. Jean Day, one of the spokesmen for the Leonard Peltier Defense Committee, was here to testify. She was not called for the defense yesterday. She was here. She was with John Graham and their family. And it's interesting that I think they are hopeful about it, but John Graham's significant other from Vancouver, British Columbia, had to get up in the middle of the processes and leave the courtroom for a while. It seemed to be emotionally upsetting her what was being said, and she's the only person that got up and left this morning. So, but I'm sure they're hopeful. I think they believe that their attorney rested the case without any calling in a witness, because his judgment was that the state had not proved the case. It's before the jury now, and the evidentiary stuff is there.
And now we just have to wait.
We'll have to wait. They could be back. Everyone's on pins and needles right now, probably on both sides. Everyone, when the jury went out, everyone broke for lunch. In the Marshall case, they came back within 3 hours and acquitted Dick Marshall. At this point, we're at the 3-hour line there. So it's going longer than that. Arla Looking Cloud's case, the jury was out probably about 6 hours before they came back with a verdict of guilty. Everyone's anticipating that we'll at least be here until late in the day. The jury has the option of going late into the night or coming back tomorrow and deliberating. There's several people who are saying that they're not planning to leave until next week, just in case the jury goes into a long time deliberation. So far, we haven't heard that they've asked any questions back to the judge or the attorneys for some guidance. So they're in there deliberating the credibility of the evidence, and we'll have to see what the outcome of 12 citizens and peers of John Graham have to say.
Well, thank you, Paul. Appreciate you following this.
Thank you, Kim.
And that's the latest roundup of news from Indian Country on this edition of the Native News Update. I'd like to thank you for joining me, and have a grand day.